Next case on the docket is Universal Map versus Mitchell. Okay, you may proceed.
Sorry, Your Honor, dry mouth.
Okay.
May it please the Court, my name is Barbara Egan. I'm here today representing the appellants in this matter, Universal Map Enterprises, the employer, and its insurance company, Star Insurance. This case involves an employee who was injured in the course and scope of her employment when she tripped and fell at work. She sought and received workers' compensation benefits and retained attorneys to sue the negligent landowners in a third-party action. When the attorneys failed to sue or to timely prosecute, she then later sued the attorneys for legal malpractice. The employer in this action filed a notice of payment pursuant to 440.39 Florida statutes. When the case settled, the plaintiff then sought a declaratory judgment action that the employer did not have the statutory lien. The appellants in this case seek reversal of the court's declaratory judgment that there was no lien pursuant to 440.39, despite the fact that the employer had paid the workers' compensation benefits for the same injuries, and despite the fact that numerous courts in other jurisdictions have ruled on this issue in favor of the lien, which I will talk about in a minute. This is a case of first impression for this court. The issue was framed in the Zurich v. Whedon case by the 4th DCA, but because of the circumstances in that case, they did not have to reach the issue. Florida has determined that a lien is available on a medical malpractice action in similar circumstances, but the issue of the legal malpractice lien comes first to this court. We submit that this court should adopt authority established in the multiple other states, including at least 6 Supreme Courts, Oklahoma, New York, Pennsylvania.
Let me ask a couple questions
about
a provision of the statute that's in 440.39 subparagraph 4A, and it has to do with the provision that says that if the injured employee doesn't bring the cause of action, that the carrier or the employer can come in and bring the cause of action on behalf of the employee, and it gives some time limits in order to do that. And so are you familiar with that part of the statute that I'm talking about?
Yes, Your Honor.
All right. And so the statute basically contemplates a cause of action based on subrogation or assignment, doesn't it? So that in the event that the employee doesn't take action to sue the tortfeasor, the carrier can come in and do it, or the employer can. Is that basically right?
Yes, Your Honor, and that is a permissive provision of the statute and an alternate remedy for the employer where benefits have been paid in a third-party tortfeasor.
My question to you is that provision even possible to apply to a legal malpractice cause of action?
In my opinion, Your Honor.
When the courts, let me finish. When the courts have essentially held that a legal malpractice cause of action is personal between the client and the attorney and is not assignable.
Yes.
Or assumable or whatever.
You're absolutely correct. And in my opinion, under the teachings of this court and courts in other states on the anti-subrogation policy and legal malpractice, that a cause of action could not be brought because of those policy prohibitions and because it would implicate the reasons behind those policy prohibitions. This case involves a lien on specific proceeds of a legal malpractice.
My next question to you is, then, if we read the provisions of paragraph 4, along with the other provisions of the 44039, why isn't it reasonable for us to say that the legislature intended that there be a right of subrogation or assignment to the carrier or to the employer against the tortfeasor that actually caused the damages, and that this statutory scheme was not intended to apply to, we'll say, a party even further removed, to wit, an attorney that committed legal malpractice that essentially had nothing to do with the injury or the cause of the injury, or the insurance coverage being obtained. So why wouldn't that be a reasonable interpretation of the statute if we read all of it together in that fashion?
Well, in response, number one, Your Honor, the statute's provisions and remedies are permissive in nature. No one has to be followed. Number two, in other words, the employer can, if the employee is seeking its third-party action, the employer has no responsibility to take any type of action, but may present its notice of payment and establish its lien, or if after 1 year no action has been taken, the employer then may sue. But I think the court, and you don't look, in interpreting the statute, you don't look on this issue as to whether every provision within the statute would apply. But I think the court does need to look, as the courts in the foreign jurisdictions that have discussed this matter, and also...
You would admit that under this provision you certainly had an opportunity to protect your interest, and when you saw that the employee wasn't taking action, you could step in and take action yourself, and you didn't do that. And so time went on, and the attorney dropped the ball, and then there was a legal malpractice action filed against the attorney, and there was a recovery. And so I'm still not exactly sure that I agree with your explanation. When we read all of this in paramateria and consider all the provisions of the statute together, that you come to the conclusion that the legislature meant that it had to do with a cause of action against the tortfeasor, and that's what this was all about, not a legal malpractice action that's personal between a client and an attorney.
As to legislative intent and what the legislature intended, Your Honor, as has been explained in multiple cases, is to prevent double recovery and to preserve our workers' compensation scheme.
Well, let me ask you about that. Would you agree that the primary purpose of the workers' comp statute is to provide a mechanism whereby employees can recover for injuries they suffer at work without proving negligence, but it also prevents employees from suing employers for what might be the full measure of damages? That would be the primary purpose.
Yes, the intent of the statute is expressly set forth in the workers' compensation law is for the employee to receive benefits, both parties to mutually repudiate their common law rights in return for an expeditious receipt of benefits, and to provide a cost-efficient manner. The statute then goes on to provide the provision.
And getting to that point, okay, so that first part, the primary purpose doesn't take away the right of the employee to sue a third-party tortfeasor for their damages, correct?
Correct, because the statutory, a provision is provided in 440.39, and this is the policy of making it a cost-effective program. If there's a third-party action, a cause of action, we're not precluding you, nor do other states preclude their employees from bringing these third parties.
And but for the provisions regarding subrogation on behalf of the carrier, the employee could sue a tortfeasor and get those damages and not have to reimburse anything to your client, correct? But for the subrogation provisions of the statute.
Oh, correct, Your Honor. It would be like any tort lawsuit.
All right.
Yes.
But then the statute gives your client the right to seek subrogation under limited circumstances. Now, the circumstances that exist here are really beyond the language of the statute. Would you agree with that?
It's beyond the language of the statute, but it comports with legislative policy, which in interpreting statutes, the statute should be interpreted in a way to support the intent and the policy behind the legislation. And in the Tool case and the other cases from other jurisdictions, they have said this consideration is paramount because it would not meet the legislative policy or intent behind the workers' compensation scheme if an employee who, you can't call it good luck, but an employee who had a third-party action whose attorneys failed to prosecute it would then receive a windfall. The employer would have paid benefits for which he could not enforce his subrogation rights.
And that's why...
And this would place... I'm sorry, Your Honor, what?
Excuse me. That's why you have the opportunity to step in and take action on your own. And when you don't do that, you do that at your peril. That's why they put the subparagraph 4A into the statute, to give you an opportunity to protect yourself. If you don't do that and the cause of action goes away against the tortfeasor, who do you blame but yourself?
Once again, Your Honor,
And so when we're talking about policy considerations, that's what the legislature intended here, and they gave you an opportunity to protect yourself and protect your interests. You didn't do it. And so then the client had a cause of action against the attorney, which is purely a personal cause of action that can't be assigned, it can't be assumed. There's no right of subrogation. And that's what the legislature intended. And so my question to you is, you dropped the ball, you didn't comply with the provisions of subparagraph 4, and therefore you're out.
Respectfully, most respectfully, Your Honor, I don't, that is not the intent of the legislature behind this statute. And in fact, I think this court even talked about that in a different circumstance in a case in equity in the C&L trucking case, where Judge Dowks talks about the permissive language of the statute, and in that case, the employer actually dropped the ball by not filing its notice of payment to even establish the lien. And if you look at this, and most employers, or many insurance companies are not going to pursue a cause of action. The legislature allows them to do so under the subprovision 4 if they wish, but the more common procedure occurs up in the other provisions of the statute where you file your notice of payment and you're entitled to a lien, and if the employee, is the employee procedure then entitled. And I do want to talk one moment about why the anti-subrogation provisions, because I believe that is a hurdle that this court must overcome, and we need to do it by analyzing the difference of the context of this case, the narrow issue before this court, that is that the entitlement to lien, not an entitlement to bring a cause of action under subprovision 4 of the statute. The anti-subrogation policy arises in the majority of jurisdictions in the United States based upon the fact that a legal malpractice is a personal tort. It implicates attorney-client privilege, it implicates the attorney-client relationship, and it is a tort that the client, him or herself, may not feel any wrongdoing occurred. So it's a personal tort we can't assign. I can't say, Judge Sawaya, you can go sue my lawyers if you think they've malpracticed. However, the cases that talk about the policy preventing subrogation or assignment do not forbid assignment of proceeds. And that is what this case involves. That is the narrow issue before this court.
Assignment of proceeds from who? The tortfeasor, the person that caused the negligent event to occur, that it essentially caused the injury to the worker.
In this circumstance, Your Honor...
The attorney had nothing to do with that.
No, the attorney had nothing to do with that, but the reasoning that the foreign courts follow in determining the manner to enforce the policy of no double recovery behind the statute is they look at what is a legal malpractice action. A legal malpractice action is virtually a suit within a suit, a case within a case. To show legal malpractice, to prevail on a claim, you must show that you had injuries that were, and what your damages and what your value of the case were. So the legal malpractice action is the functional equivalent of the third-party tortfeasor action against the initial wrongdoer. And that is how, analytically, the courts reach the conclusion that the policy behind this statute is paramount for enforcement. We have determined, we legislators, that the employer under the scheme must pay the benefits, but the employer should not have to pay benefits when the employee has recovered damages for the same injuries that the employer has paid. This is the cost-effective umbrella of the system. So I submit that in this case, to support the legislative policy behind the lien provisions, I do not submit that if in this case we were attempting to sue for malpractice, the statute would permit that. That's a whole different ballgame. But that under the provisions entitling us to assert a lien, which will be in this case a lien on proceeds that arose based upon injuries which we had already provided compensation benefits for. So we've got a plaintiff who, we have a plaintiff who would be receiving potentially a windfall recovery. We don't know how much the lien right now.
Windfall recovery because
they received benefits.
A windfall recovery because you did not avail yourself of the provisions of subparagraph 4A and do it yourself. You let it go.
Once again, Your Honor, I submit that that is a permissive provision. There is no obligation under this statute for us to do that.
The legislature doesn't want to force you to do anything. They're just giving you an avenue to protect your interests.
And they've also given me the separate and distinct avenue of enforcing a lien. I have no obligation to also sue. And I'd like to reserve, if I may, the last 3 minutes.
Okay, thank you.
May it please the Court, good morning. I'm Joe Williams, for the record, and I represent the appellee in this matter, Alice Mitchell.
Mr. Williams, as a practical matter, is your client getting a double recovery?
I don't think so, because they are two entirely different causes of action.
Well, but let's say your client suffered $100,000 of damages between pain and suffering, medical bills, and lost income. And you receive your client received $55,000 from the workers' comp carrier and $100,000 from the tortfeasor. So theoretically, did your client get $155,000 for $100,000 of injuries?
The reason, if I may, I would like to speak to that without a direct answer to your question right now. We're talking about two different causes of action here. One is the cause of action against the tortfeasor for the negligent injury of my client. The other action we're talking about is a legal malpractice action. And I cited to the court the case of Shaw versus Cambridge.
I understand that, but your legal malpractice, what are your damages in your legal malpractice? The damages that you suffered in the personal injury case, correct?
If I may, in Shaw, they cited a Supreme Court case, a Humana Workers' Compensation. This was the spoliation case where the company spoliated the ladder that caused the on-the-job injury, and then the employee sued the employer for that. And they cited, and they allowed that, and they said that's a tort, that's not a workers' compensation claim. And the court cited the Supreme Court saying negligent spoliation of evidence is a tort claim based on a defendant's breach of duty to preserve evidence. The damage that flows from such a breach is the resulting inability to prove a cause of action.
But I'm going to shoot for a yes/no answer here.
The employees...
Now, did your client get more, did your client get a double recovery?
My client made a recovery. There is nothing in evidence in the record before this court as to what that recovery was. There is nothing in evidence as to what the amount of my client's comparative negligence, if any, was. There is nothing on which any kind of assessment of whether a double recovery has been made.
Well, based on the trial judge's ruling, we never got to those issues.
I'm sorry?
Based on the trial judge's ruling, we never got to those issues.
That's true.
But accepting your argument, would it allow your client to get more of a recovery than the damages he suffered or she suffered as a result of the personal injury?
I don't think so, and the reason I say that is because of the factor of comparative negligence. All right?
That's not a factor in workers' comp, is it?
It's not, but it is when you're talking about what you get in the third-party claim.
Well, let's assume there was no comparative negligence by your client.
If there
If
were...
we accepted your argument, would your client get more money for her injuries than she actually suffered?
If there were no comparative negligence, the client would get more money, but it would be for two different causes of action with different criteria as to why you got paid.
All right, so if we accept your argument as far as future cases, would it mean that a client would do better if their lawyer committed malpractice than if their lawyer didn't commit malpractice?
It could. Again, depending on that element of comparative negligence, which is always the wild card in determining, whether how double the recovery is going to be.
Should we be concerned about that our decision wouldn't encourage lawyers to commit malpractice, but it would just have that effect, if you would?
Well, I've been doing this for almost 35 years now, and this is the first case I have ever had where an attorney failed to file a lawsuit on a workers' compensation claim for whatever that's worth. So I'm not sure it's a huge problem, but I think that if an attorney fails to file a case against a tortfeasor and then the client recovers for legal malpractice, yes, in some instances that person is going to recover more money than they would if the tortfeasor had been sued and the normal equitable distribution process had taken place.
Okay, thank you.
Okay. The employer carrier referred to what Ms. Mitchell received as a, quote, double recovery throughout her brief and throughout her oral argument here today. Again, that's not entirely true because of sometimes people don't get everything that they should get or would get if they hadn't been comparatively negligent. So, and this is a fall-down case that we're talking about. So I think it's not exactly accurate to talk about a double recovery as if she's going to walk away with double, what she would have gotten from the workers' compensation case. I have to address the cases from the foreign jurisdiction that my opponent has cited in her briefs and has argued to the court. When I was in law school, when I was a freshman, they told us that we have 50 laboratories in this country where the states individually address their own problems and social issues, and they come up with solutions to those issues. And the ones that fail, maybe they adopt another state's solution. The ones that are successful, they are adopted by other states. I think our system in Florida, our laboratory has produced a pretty good result for subrogation and workers' compensation claims. And I think this court's decision in the Southern Construction Company versus Greater Orlando Aviation Authority case, you said that whatever subrogation rights an employer carrier has are to be found within the four corners of the subrogation statute, 44039 of the Florida statutes. And you said that if the legislature, in the case we're talking about where an employer was trying to sue somebody for getting his insurance premiums raised, you said that if the legislature had intended for that kind of recovery to be made, the legislature would have put it in the statute. And I think that's the same situation we have here. If the legislature had intended to allow a carrier to subrogate for legal malpractice, I think that would have been in the statute. In Oklahoma, one of the cases that is relied on by the employer carrier, there is a statute in that state that says a carrier can sue an attorney who fails to file a suit within the statute of limitations. We don't have anything analogous to that in our state. In some of the other states, in Massachusetts, they define a third-party tortfeasor as some persons other than the insured. That could be the whole world. We have a very explicit definition in our statute. We use the word joint tortfeasor, and I tracked the judicial construction of that term. It has a well-understood, well-known meaning, and the joint tortfeasor was the person who caused the injury. The attorney who failed to file suit on time, that's a separate and distinct injury than the one that Ms. Mitchell suffered on the job. And the employer carrier has never come to grips with that. I talked about the definitions in the statute that I think are just crucial in your consideration of this case. The statute defines an injury as an accident arising out of the course and scope of employment. They define the term arising out of as occupational causation. Now that means that something had to have happened on the job site that caused the accident and caused the injury that was suffered by the employee at that point. And that doesn't apply here. There is no way that an attorney failing to file suit 4 years after the accident happened can be that cannot be transmogrified into a workers' compensation claim, because there is no occupational causation. Nothing Ms. Mitchell did or didn't do caused the attorney to file the lawsuit late. We talked about the assignment of legal malpractice claims, and I'm here that the panel is familiar with that line of authority. I think that's all that I have. I would ask that the court affirm the final judgment on appeal and remand it to the trial court for taxation of interest, or figuring interest and other matters associated with winding the case up. If there are any other questions, I'll be happy to answer them.
Thank you, Mr. Williams. All right. Okay, 2 minutes and 45 seconds.
In conclusion, Your Honor, I would like to clear up some points that have been made in opposing counsel's argument. In my briefs, in my argument to this court, I am not in any way asserting that the plaintiff in this case received a literal double recovery. I've used...
We don't even know what the recovery...
No.
Is it in the record what the recovery
No.
was I keep wanting to say legal malpractice cause of action?
I
don't
believe
even
it
know
is,
what that-
it is in the record as to what the settlement amount was.
It is?
But the issue, and both parties agreed, and it's in the transcript of the proceedings before the trial court, both parties agreed that Mr. Trial Court Judge, we are here today to determine a very narrow issue. Are there lien rights to the medical malpractice, to the legal
No, I got you
malpractice
going.
proceeds?
I should be quiet.
And the issue of what what amount the lien would entail would be an issue that would go back to the trial court for determination under the statutory scheme. So what I wanted to clear up is I am not asserting to my opposing party or to this court that my client got double what my client would have gotten. This is just kind of the term of art when people talk about the policy. And I'm sorry if that was not clear, because I do not want any misunderstanding.
You want to say that they perhaps recovered more than they otherwise would have?
Even though maybe a windfall. Maybe it's $8,000 ultimately that would work out, and her settlement was $100 and something thousand.
But if you rule against...
But I just want to make that clear. I'm not trying to say she received a double recovery. I'm using the term of art in the other jurisdictions. Got 39 cents.
But if we rule contrary to your position, we would create the opportunity for that to happen.
Yes, Your Honor. And I also want to make clear that workers' compensation is kind of a strange area of law, and that the court, the First District Court of Appeal...
There was an assertion before that that this may bring about more legal malpractice in order to get more money for the client or double recovery. Do you in any way assert that given what an attorney has to go through in defending a legal malpractice action, and the fact that in some instances attorneys pay that out of their pocket, that would encourage that sort of thing?
Your Honor, I think that would be an absolute ethical obligation of our oath of office, and no, I do not.
Okay.
I would think there would be no, because what benefit would it be to the attorney too, notwithstanding our professional? But I just want to point out in conclusion that the authorities from other jurisdictions in the workers' compensation arena are very persuasive. Even though there are some differences in statutory language, the scheme's the same. It's evolved for almost 100 years in every state, and the courts do look to what other courts have decided. In fact, shockingly, I read a case recently where the appellate court was chiding counsel for having not brought to their attention authority from other jurisdictions on a case of first impression. Okay. So I did want to clear that up. And we would request that this court reverse the determination of the court below, return it to that court to determine the lien amount.
Okay, thank you very much.
Thank you, Your Honors.
Time is exhausted. Well argued on both sides.